Hi, everyone. Harry here to talk about the decision signed into law yesterday by Louisiana Governor Jeff Landry to require the display of the Ten Commandments in every public classroom in Louisiana, require it of a certain size and font, and be just as it sounds. Now, you might have thought, wait, can they do that? Isn't it unconstitutional? And the answer is, that's right. It is unconstitutional under the very strong precedent of the U.S. Supreme Court. I'll get to it in a moment. But this enactment is designed as a kick in the teeth to Supreme Court constitutional doctrine. That is, they know that it is unconstitutional under the law of the land, supposedly, and they do it anyway, inviting the lawsuit. So the governor says, I can't wait to be sued, and we're ready to take on. And Landry says, look, if you want to respect the rule of law, you've got to start from the original lawgiver, which was Moses. You will see that quote brought back up repeatedly to show what the design was, along with others of the proponents who, it's clear what they are doing. It's imperative we put the Ten Commandments back in a prominent position, says the Republican sponsor. The measure allows for our children to look up and see what God says is right and what he says is wrong. It doesn't preach a certain religion, but it definitely shows what a moral code we all should live by is. Okay, so there as well, that it's just suffused with religion. The sponsor is getting at the notion that the Establishment Clause might protect only against the establishment of a particular religion, like Christianity. But this is all religions. Of course, that's false on the facts. This is the Judeo-Christian basis. That's just not in other places. And it doesn't matter. The First Amendment, it's clear, forbids an endorsement of religion. So this is a very aggressive move, and it just goes to show what's happening. We will now, over the next couple of weeks, chronicle and probably in some instances lament the constitutional rollback that this uber conservative court is in the process of doing. But it's not just that. The impacts here, you have a not just cadre of certain state governments, but also in concert with certain organizations, especially those dedicated to conservative causes, especially those dedicated to religious causes, to do in this latter instance of religious causes, as I see it, precisely what the Establishment Clause forbids, and precisely why it forbids it. So this frontal attack on Supreme Court precedent is emboldened in part because of the ruling a few years ago. And remember the coach praying on the 50-yard line and the twisted version of facts that the court imposed in order to uphold it. The then prevailing test that was used in 1980 to strike down the display of the Ten Commandments in Kentucky, I believe it was, is now been is by the books. It's no longer controlling. It's the Lemon test. It was on the hit list prominently for conservatives for a long time, and it's one of the things that they've taken out since the new uber conservative majority has come on the court. It had a test that said if any of the following three things happen, you either have a primary religious purpose to in your action there, putting the Ten Commandments up, or it's got the effect of promoting religion, or it leads to excessive entanglement with religion and the state. It's no good and violates the Establishment Clause. That, for a number of reasons, always stuck in the craw of conservatives, and the court has disavowed it, won't be deciding cases according to that. Just to take a step back, though, what happened in 1980, Kentucky did this, and the court, in a per curiam opinion, which is when they do to really emphasize they're speaking in one voice, summarily reversed. That is, without even going through oral arguments and the like. They just said, "What, are you kidding? Forget about it." And said, this is out. And because it has even though there were lawmakers who said, no. And this is what they'll say also in the current case that that Governor Landry has done for Louisiana. The Ten Commandments is a religious document, but it's also a foundation of our moral code, and it's really teaching a general underpinning that, and also giving us sort of the history of this country and how it's founded on principles that, yes, are religious, but also have larger purchase. It's that kind of argument that was specifically trashed or disavowed in the 1980 Supreme Court opinion, where they said, essentially, come on, Ten Commandments, this is a primary religious purpose. And they had some quotes to display for that, but none as vivid as what I just read to you up top. We want, everyone to know what God says is right and what God says is wrong, and bring it on. So there's not the slightest doubt that this action is inconsistent with controlling Supreme Court doctrine as it is still on the books. And that they're doing it specifically to challenge that and try to change the law, buoyed by their knowledge that there's a new sheriff in town, or 6 sheriffs up on the Supreme Court, and they can actually undo a really long-standing and long-standing precedent, certainly in terms of result, but they'll say the Lemon test, has been undermined, so maybe this is undermined as well. But the thing to emphasize here is they're really trying hard to actually change the law as the whole point. So this happened even before Dobbs. Certain states, on a hope and a prayer, but not any good faith belief in what the Constitution actually provided, went way out in front, thinking that the Supreme Court might validate their position when it got to Dobbs, as indeed it did. Although you would think a court that is very vigilant about the rule of law would first strike down any effort to go afoul of the law as it then stood. I mean, this is a clear instance, as is Louisiana, of just dereliction and disobedience with the law by a state court. And on who is it to say, well, we think the U.S. Supreme Court might come out this way if we did it, so we will act in a way that's clearly constitutional now. That's all that this statute is, and it's confrontational and provocative for precisely that reason. So if you just you could run it through the old Lemon test and see what the court's concerns were then we have a purpose for sure, and the effects for sure. And then just think about the entanglement. So the need for every primary school teacher to be involved and validate the choice of Louisiana. Let's say some kids don't want to, don't like having the Ten Commandments there. There's a need now for the educators in primary schools across Alabama to try to explain this is now the policy of the government of the state, the Ten Commandments, and how is it just a code of conduct or of moral probity as opposed to a religious doctrine. It's not, and if teachers have to somehow justify it, they're going to be tangled in knots. So anyway, the enactment, I'm trying to do it very sort of soberly and in objective terms, but it's a complete violation of the Establishment Clause as we now understand it. And if the court eventually comes to uphold it, let me say one thing, which is in that initial case, there was a lone dissent, then Justice, later Chief Justice Rehnquist. And really all he said was, you should have given more deference to the legislators' avowal that they had a secular purpose. And here, even if that were entertained, you don't have a secular purpose, or at least you have a very strong religious one when you have the sponsor of the bill saying we want every kid in Louisiana to know what God thinks is right and what he, as the sponsor puts it, thinks is wrong. And just a step back without legal tests, this is, it seems in a very straightforward, commonsensical way, the endorsement of a religious viewpoint by the state of Louisiana in every public school classroom in the state. So it's a raw effort to lurch the law in a pro-religion by the groups, by the way, that is their avowed purpose. They are, that they think there should be more religion in American public life, whatever the Constitution might or might not say. And this is a very, raw and blatant attempt to do it. And if it is eventually upheld, it will be of a piece with the huge social dislocating lurches right that the Supreme Court has affected in not just the law, but American public life. If that becomes the law, and we now show up and see, prominent in our classroom, a attestation or a code drawn from the religious text, drawn from the Bible, that's a different world. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.